Hello, everybody. I'd like to welcome you to the first of this afternoon's panels on whether there are limits to government surveillance. I think this panel represents, in some ways, the first take on the Auden poem, or the excerpt of the Auden poem that you have on your carrying devices. I'd like to introduce our panelists. They're going to give you very brief presentations, and we're going to try to facilitate as much dialogue back and forth with the audience and across the two panelists as well. On my right is Ben Wizner, who is the director of the ACLU Speech, Privacy and Technology Project, and is also known as the legal advisor to Edward Snowden. And on my left is Fritz Schwarz, who is chief counsel currently for the Brennan Center for Justice at NYU and was chief counsel to the Church Committee. So I'd like you to join me in welcoming them to this panel. We're going to go in the order in which they appear, so please, Ben.
Thanks, Kathy. Thanks, Roger, and everyone who was involved in organizing this conference, and especially the students. And thanks, Fritz. What a pleasure for us to be able to have this conversation about parallels between the two great surveillance debates that we've had in this country in the last half century or so. Not everyone knows how the last great surveillance debate began, but you could trace its roots to a spectacular act of lawbreaking, just like this one. In 1971, a group of anti-war activists broke into an FBI field office outside of Philadelphia. They called themselves the Citizens Commission to investigate the FBI. They stole all of the files. They put them in suitcases. They drove them to a safe house, put on rubber gloves, looked through them, and then mailed them off to various newspapers, including the Washington Post, which ultimately published these secret documents that revealed really extraordinary and ultimately very, very controversial FBI domestic spying operations aimed at anti-war groups, black student groups, other dissidents from Nixon's America. One of those documents in the corner had a word, and they didn't know what it was. The word was COINTELPRO, and maybe Fritz will tell us a little bit more what COINTELPRO was, but it began the process of unraveling the full extent of the FBI's illegal domestic surveillance operations. So some of the parallels to the post-Snowden debate are obvious on the surface. Like I said, both began with these very dramatic acts of law-breaking that paradoxically ended up revitalizing democratic oversight. In both cases, the surveillance practices that were revealed were justified as necessary responses to a war. Of course, under Hoover, it was the Cold War, and under Bush and Obama, post 9/11, it's been the so-called war on terror, or the global war on terror. Both of these episodes involved larger-than-life government bureaucrats. Most of you will be familiar with J. Edgar Hoover, who became the director of the FBI at the ripe young age of 29 and held that position for 50 years, an extraordinary thing in a democracy to have a secret police chief who can hold a job for half a century. You may be less familiar with the NSA's General Keith Alexander, who ran that agency until quite recently. General Alexander is an extraordinarily skilled bureaucrat, and I use that term non-pejoratively here. He really understood how to use the levers of his own power in order to aggrandize his agency and get more authority. There's a remarkable profile of General Alexander in Foreign Policy magazine by a reporter named Shane Harris. I want to read to you from some of it. According to Harris, and we know this, Alexander's strategy was to collect it all. This was a kind of mantra for him. We're going to collect everything we can, and the authorities and the budgets will follow. General Alexander created something that he called the Information Dominance Center. This was his headquarters. And this is I'm quoting from this foreign policy piece. It had been designed by a Hollywood set designer to mimic the bridge of the Starship Enterprise from Star Trek, complete with chrome panels, computer stations, a huge TV monitor on the forward wall, and doors that made a whoosh sound when they slid open and closed. Lawmakers and other important officials took turns sitting in a leather captain's chair in the center of the room and watched as Alexander, a lover of science fiction movies, showed off his data tools on the big screen. And of course, this was how Alexander both intoxicated those who were supposed to be doing oversight and also threatened them. Now we know that J. Edgar Hoover's threats were crude. It was understood in Washington that he had a dossier on almost everyone in power, and so there was an implicit blackmail if you were to go up against him. With Alexander, it wasn't so vulgar at all. You just knew that if you voted against the NSA on a question of budget or a question of authority, the finger was going to be pointed at you if a terrorist attack occurred, and it's a different kind of, you might call it, democratic blackmail. Both of these episodes led to what you might call constitutional moments, a moment when there's a broad consensus that government practices have outpaced democratic controls. In the 1970s, there was an enormous loophole in the Fourth Amendment. The doctrine was that if you were doing surveillance for intelligence purposes and not for criminal purposes, the Fourth Amendment simply didn't apply at all. And so under this foreign intelligence exception, the three-letter agencies in the US opened up files on hundreds of thousands of American citizens, almost none of whom actually had connections to foreign intelligence operations. And what is the loophole? I guess loophole might not even be the right word now, but the Fourth Amendment gap that the NSA scandal has revealed is that the government has essentially allowed capability to dictate practice. And the rule that they've devised is that they can collect and store anything they want with no legal restraint, and the law only comes into play when a human being queries a database in search of something specific. But they can collect everything. Now, we know that they were collecting the metadata from all of our phone calls, but nothing in their legal theory would have prevented them from collecting the content of all of our phone calls or even putting video cameras in all of our homes, so long as an individual didn't look at it. For that, they needed some other kind of permission. Now, I know that some people will object to the comparison of Alexander to Hoover, and I think that those objections have some validity. I mean, certainly there's a big difference between a secret police chief who targets political enemies and threatens to blackmail civil rights leaders, and one who oversees the kind of passive collection of all of this kind of information. But of course, technology has liberated our spy agencies from those vulgar methods. Now they can collect everything without having to make those targeting decisions now, and they might make them later. I think we need to be concerned. The question is, are there limits on government surveillance here? Yes, of course there are. There are limits. The limits on the NSA's practices right now are in hundreds of pages, thousands of pages of arcane rules. The question is, how confident are we in those rules when they're engaged in the kind of voracious collection practices that they are? How robust are those rules going to be in the face of a terrorist attack or another war? Tomorrow, Scott Horton, who's sitting here, is going to interview Robert Litt, who is the chief lawyer for the Department of the DNI. Directorate of National Intelligence. One of his emails was leaked to the Washington Post a few weeks ago, in which he lamented that his side was not winning a policy debate, but suggested that the debate might shift if there were another terrorist attack. He was being honest, but that is actually the way that the intelligence community thinks. The Patriot Act was written before 9/11, not after. And you can be sure that if there is another terrorist attack, because we have these massive databases, these surveillance time machines, that information that could have in theory prevented those attacks will be residing in these databases, and the attacks will be blamed not on intelligence failures, but on rules that prevented them from looking at this information. And so we can't just consider what limitations there are on collection today. We have to have a clear-eyed view of how those rules will survive another kind of trauma like the 9/11 attacks. Should we worry about this world of collection? I'll close now because I want to get to the conversation with Fritz. The security technologist Bruce Schneier, I think, puts this very well. He says, when you're driving and a police car pulls up alongside you, how does it make you feel? Do you feel safer? Do you feel more secure? How would it feel to have that feeling all the time? To feel that way constantly? This entity that is there to protect you is always right there. That's the world that we are sort of sitting by as it's being built by spy agencies and others. And it presents a totally different set of challenges, I think, than what Fritz was up to in dealing with the goons of the Hoover era.
So, thank you, Ben, and I really admire your client and your protection of your client. Thank you, Kathy. Thank all the students here and all the other guests. This is and by the way, the break-in in Media, Pennsylvania, there's a great documentary people should visit and see called 1971. It's about that break-in and very good. The church committee that I was lucky enough to be chief counsel of at the age of 39 had nothing to do with the church. And this may be something new to the students. It was named for Senator Frank Church from Idaho, who was the chair of the committee. And that committee conducted the most extensive investigation ever in the United States or ever in the world of the secret government, and made the greatest disclosures, the most extensive disclosures there ever have been of the actions and misconduct of the secret government. So we're here to talk, as the last questioner right before lunch pointed out, there's a big difference between state surveillance, government surveillance, and corporate surveillance. And we're here to talk about the government surveillance side of that. The first point that I would make is that exposure is sometimes needed to protect privacy. And by that I mean exposure of the government is sometimes needed, often needed, to protect privacy. The second point I would make is that surveillance is not a partisan issue in this country, and actually never has been. Back in the time we covered, the committee, I think our single most, it was 6 Democrats and 5 Republicans, and we never had a partisan vote on the committee, never once broke by party. And probably the single most important finding of the committee was that every president between Roosevelt, Franklin Roosevelt, and Richard Nixon had abused their secret powers. Now, the issue of surveillance is nonpartisan in 2 respects. First, over-surveillance, bad surveillance, has come from both parties. Second, that it is too much is a view that is held today by both parties, as particularly revealed by the reaction in the Congress to the Snowden revelations. Now, let's do the conduct side. In what we looked at, by the way, I've also focused on the current issues, and I just wrote a book called Democracy in the Dark, The Seduction of Government Secrecy, which is about these subjects. But in the Church Committee's work, looking backwards from 1975-76, the bad actors were included not just Richard Nixon, but every president, and let's focus on the sainted Franklin Delano Roosevelt, who was brought up within a few miles of here. It was Roosevelt who authorized J. Edgar Hoover to investigate subversives. Prior to that time, the FBI had been, at least in theory, constrained to investigate violations of law, but once the door was open to investigating subversives, you got investigation of opinions and status in the world, as opposed to breaking the law. Franklin Roosevelt told Hoover, go ahead and investigate subversives, and they agreed with the Attorney General that neither the Congress nor the American public should be told about that. Then again, with the correctly sainted, but here erroneous Roosevelt, when Attorney General Jackson ruled that the FBI could no longer conduct warrantless wiretapping and warrantless bugs, based on Jackson's view of a Supreme Court decision, Franklin Roosevelt wrote him a letter saying, I disagree with your analysis of the law. Go back to allowing the FBI to do warrantless surveillance. And that led to many, many very bad things. Now, going forward, I could make the similar comments about John Kennedy or about Richard Nixon, or all the group of presidents there. But going forward, the bad acts after 9/11 were a product of a Republican administration, the BushCheney administration, and the extensive departure from the new rules that limited surveillance and required a warrant for intelligence wiretapping. The Bush-Cheney administration, and those rules were put into effect as a result of the Church Committee's investigation. The Bush-Cheney administration disregarded those rules and proceeded in the teeth of the law, based on ridiculous interpretations of the law by people in the Justice Department, proceeded to return to the world of warrantless wiretapping and the sweeping world of the NSA surveillance. Exposure comes not only from congressional investigations, exposure comes and always has come from the newspapers. Journalism is vital to American democracy. De Tocqueville said it was the key to American democracy. And after James Madison said the public is the true sovereign in a democracy, Congress passed the Post Office Act that subsidized newspapers and that resulted in about 1830 or 40, 90% of the weight of the material sent through the mail were newspapers, but only 10% of the revenue were newspapers. Newspapers have been key, they're still key, and we have to worry about the future of investigative journalism. Now, Hannah Arendt, well, let me make a point about Abraham Lincoln. And I think if we think about solutions, Lincoln, as always, had the right analysis. Lincoln said, with public sentiment, there is nothing you cannot do, but without public sentiment, there's nothing you can do, and that is why people who mold public sentiment are more important than judges or legislators. And Hannah Arendt was referred to, I think, in Roger's talk this morning as having referred to the importance of the arts. And on this subject, the arts have indeed been very important in the molding of public opinion. George Orwell's 1984 book, the movie The Lives of Others, which displayed the horrible impact on the person, on the person's integrity, on the person's privacy of extensive surveillance by the government. So opinion, the idea of sentiment, by the way, a much better word than public opinion. Lincoln's phrase public sentiment refers to a deeper and stronger view than just reactions that are instantaneous and that are so-called public opinion. So I want to finish now, so we have lots of times for questioning, with referring to two of what I call the hymns of American history. And these are hymns that express the importance of openness. One is in the Declaration of Independence, Jefferson's Declaration of Independence, and the hymn language in there's plenty of hymn language, but the piece that I want to refer to is Jefferson's statement that a just government is based on the consent of the governed. But if the governed are uninformed because the government is hiding too much information, how are we going to have informed consent? And therefore, we cannot have a just government. Excuse me. And then the second hymn is Lincoln's Gettysburg Address, where Lincoln says at the very end, basically, we shall fight to ensure that government of the people, by the people, and for the people shall not perish from this earth. But to have government by the people, once again, you cannot have a society in which the government is hiding much too much of the information that is necessary for the citizen to perform their God-given or Thomas Jefferson-given or constitutional-given right to control the government. So thank you.
I think we're going to have ample time for questions, and if I can launch with just one that builds off of the comments we've just heard about capability dictating practice. If technology provides the potential, as you talk about in your book in the conclusion of Democracy in the Dark, for over-surveillance, and it's been exacerbated by outdated policies or rules that perhaps we don't even know about, I suppose I'm going to ask Lenins question, what is to be done? And how can we do whatever it's necessary, whether it's enhancing the sentiment of, or the awareness of people to raise public sentiment against it, without undermining what you also, Fritz, talked about as the legitimate capacity of government to protect certain secrets or gathering information that would prevent future attacks?
Well, I can make two quick comments. One is, it's amazing how the pace of technological change since 1975 and today. We made revelations about the NSA. For example, from 1945 to 1975, the NSA got copies of every single telegram that left the United States. And we looked at and didn't talk too much about the nature of the technology they had to do quite complicated and intrusive things. And Frank Church on one of the Sunday programs once said this technology is so powerful that someday, if it keeps going, there'll be no place to hide, which those words were the title of the book written about Edward Snowden by Greenwald. But if you think about it, the technology of 1975 was truly the Stone Age compared to the technology of today. But my other point about technology, which I discuss in the end of the book, is actually the best people, the smartest people in the CIA and the FBI have concluded that given today's technology, and I'm not going to explain the reason for this, but they've included that because of today's technology, the national security is actually being hurt by there being too many secrets because they make it harder for the people in government who are trying to do good things to get vital information to the right person as quickly as possible.
They're also drowning in information because of the overcollection. I also want to make two quick points about technology, both of which I think lead to the same conclusion. The first is that it's neutral. So there isn't any surveillance technology that is necessarily pernicious. I mean, take something really creepy like surveillance drones. I think even most Americans who claim not to worry about surveillance don't really like the idea of drones flying over their cities all the time and recording everything. But that same drone might be a valuable weapon of human rights if we could fly it over a conflict zone in South Sudan, or of police accountability if we could fly it over a place where police violence is occurring. So the technology itself is neutral. The second point I want to make is that surveillance technology has gotten too cheap. Ashkan Sultani, who's going to speak next, has written a great article about this, just about how the relative cost of surveillance has plunged so much that where governments used to have to make resource-based decisions about who they were going to follow, now they don't. And so if 20 years ago my local police department wanted to know where I was over an extended period of time, that was going to be a fairly expensive proposition. They were going to have teams of agents following me around the clock at great cost. Now, of course, any police officer in America with a laptop can tap into a database with one of the phone companies and get this information about all of us over months and months and months. And so we're going to need rules where perhaps we didn't always need them before. It may be that our principal protection against this kind of tracking in the past was not law, but was cost. And now where cost puts up no barrier, and even storage, which used to be quite expensive digitally, is now practically free. It's now possible for governments to track almost all of our actions, communications, contacts, and store them forever at really, really, really low cost. And so we have to make normative decisions that are enforced in law about what the limits should be on that. And so we may need things like warrant requirements where we didn't have them before to protect us against abuses. But that's how I think technology has complicated the picture.
Thank you. Thank you. Could we have some questions from the audience? Over there? Is there a microphone? Just a second. Hold on. Someone's coming with the microphone.
Thank you. We have, in addition to surveillance of the public, we have surveillance today of potential terrorists, and we have surveillance of foreign governments and foreign interests. And the question is, how do you separate it? And I think in the case of Snowden, that line has been crossed. And how do you separate the two, and where does the public interest come in?
Well, I think questioning the judgment of where the lines have been drawn is completely legitimate. I would say that the lines that have been drawn by journalists. Everything that we know from the Snowden revelations, we know because journalists and editors at The Guardian or The Washington Post or The New York Times or the other publications that got access to the documents made a determination that the public interest favored disclosure rather than withholding it. They've still only published, a small amount of the information that they've been given, but it's not always so easy to draw those lines. And so you might say it should be disclosed if it's in the public interest, and it should be withheld if it would cause some harm to national security. But let me give you a hard example. You're a newspaper and someone has given you the photos of prisoner abuse at Abu Ghraib that have never been published before. It's hard to argue that there was not a strong public interest in publishing those images so that Americans and other people around the world could see what was done in our name. And it's equally hard to argue that the publication of those images didn't lead to the death of American soldiers in Iraq, to the recruitment of terrorists and adversaries, right? I mean, sometimes these interests collide. On the surveillance side, the New York Times published on A1 a very important story about how the NSA had worked to systematically undermine commonly used encryption algorithms. Now, this was a closely held source and method of the NSA. And so for them, publication of this was, a calamity. This is a tool that we have that we can use against all kinds of adversaries. But the New York Times made the determination that because we all rely on encryption, because our businesses rely on it, our economy relies on it, that it was important for the public to know that these systems that we all rely on have been weakened. And certainly that story caused more anger in Silicon Valley than almost any other. Is it an easy decision to say where to draw that line? It's never been an easy decision for journalists to make those kinds of determinations. I will say, though, that it's unlikely that the articles that have been published about the NSA disclosed information that was unknown to our sophisticated adversaries. Just as the NSA knows everything about how China and Russia conduct surveillance, so do China and Russia and Israel and France know everything about how the NSA conducts surveillance. And so the only people who actually had something to learn from these disclosures were those of us who, after all, in a democracy, should be the ones making the decisions about whether these practices are appropriate.
I mean, to put that another way, far too often things are kept secret not to protect Americans against danger, but to deprive Americans of information. That being said, you have to accept that there are legitimate secrets. Someone who enters this field and doesn't do that is going to fail, and they're wrong. But on your comment about Snowden, first let me give my personal reaction and then a more important reaction, which is Congress's reaction. My personal reaction is that Snowden was motivated by a desire to help America, number one, and number two, that his actions did help America. Now, that's just my personal reaction, but let's think about the Congress. And by the way, this proves my nonpartisan point that over-surveillance issues are not partisan issues. The minute that Snowden's revelations about collecting so-called metadata came out, Congress, the House of Representatives, almost passed a bill right away eliminating the federal government's NSA's ability to collect metadata. That bill was sponsored by one of the Tea Party Republicans, a man called Justin Amash, and who was a very conservative person, and it was co-sponsored by John Conyers, a longtime Democratic congressman from Detroit, who's a very liberal person. A year later, the bill eliminating NSA's metadata program actually passed the Congress, and in the Senate, the sponsor was a very conservative senator from Utah, I think his name is Mike Lee, and the co-sponsor was a liberal Democratic senator from Vermont, Patrick Leahy. So the Congress as a whole reached the conclusion that what Snowden had done had helped the country, and it makes my point that fortunately, the concern about excessive government surveillance is not a partisan issue, and therefore that gives us a better chance to wrestle with it than with many of the other issues that are facing our country.
Questions? Yes?
To no sound. Oh, to sound. Hillary Clinton, when Anderson Cooper asked everybody on the panel, as it was, about whether Edward Snowden was a hero or a traitor, her comment was the most sort of hard-edged, and she said, one, that he had broken the law, two, that he wasn't really a proper whistleblower, and three, that, and this is different from what some of you just said, that some of the information had fallen into the wrong hands, I think was her phrase. And I'm wondering whether that is true, or whether she was just putting herself in a particular position.
You know, my reaction when I heard her say that the information had fallen into the wrong hands is that from the point of view of the government, the public are the wrong hands. There's no evidence that they've fallen into the hands of any adversary. In fact, the only entities that are known to have let information fall out of their hands are the NSA and the British GCHQ, which allowed a 29-year-old contractor to walk out the door with what they say are their crown jewels. You know, it was nice to see that statement by by Hillary Clinton was pretty well fact-checked by the media the next day. And I won't stay on this long because it's a little bit afield from our subject, but suffice to say that under our law, under the 1917 Espionage Act, the charges against Snowden are basically strict liability offenses, by which I mean there is no defense. So while he would have a trial by jury, it would really be a formality. Based on his public statement that he was the one who provided this information to the journalists, there's nothing else that needs to happen at a trial. The fact that those journalists won the highest prizes in journalism, the fact that the disclosures led to rulings by courts that the programs were illegal, historic action by Congress ending one of the programs, a global debate that we haven't seen in at least a generation, none of that would be relevant or even admissible in a trial of Edward Snowden under the Espionage Act. And that's why he hasn't come here to, in her words, face the music. Speaking of facing the music, this week the ACLU brought another lawsuit against the architects of the CIA's torture program. To this day, no one who participated in either the torture program or the illegal surveillance program of the Bush administration that Fritz talked about has faced the music. But evidently, the music is only for 29-year-old contractors, not for the leaders of the state.
I thought it was a low point for Hillary Clinton in what was otherwise a pretty good debate. On the whistleblower point, impossible that if he'd gone to NSA that they would have done anything. This was their God-given right. They wouldn't have done anything. If he'd gone to the Congress, the people on the Intelligence Committee already knew this information, but under the rules, they weren't allowed to make it public. So her whistleblower argument had no substance behind it. And info falling into the wrong hands. First, there's your point that our adversaries are, Chinese, for example, are highly sophisticated in what they can do about our information. But the second point against that is that every single example that the government has come up with about things that Snowden revealed that were harmful had been revealed often by the government itself, but it already was revealed. So not proper substance in support. And finally, there's a terrible double standard here. Snowden is facing, Bradley Manning, who did release some things that shouldn't have been released, but certainly didn't deserve to be tortured as he was before he went to trial, or be sentenced to 35 years. But the double standard is the government lies about these things, lies to Congress, and nothing is done about the government person who lied to Congress. I mean, there was a high official in the government who flat out lied to the Intelligence Committee about the existence of the program that Snowden revealed. And unfortunately, I'm not sure he should have been prosecuted, but at least he should have been sanctioned, and the president should have said that was a bad thing to do. That is a bad thing to lie to Congress, but there's a terrible double standard on the revelation of secrets.
Do we have some questions from students? Is there a student? Over here, yes.
Could one or both of you just talk briefly about the process for obtaining warrants to view the information that's collected, how it's done now, and how it ought to or could hypothetically be reformed? Thanks.
Well, why don't I start on that? After the Church Committee's investigation, Congress passed a law called the Foreign Intelligence Surveillance Act that required warrants to be obtained for basically national security wiretaps. And it worked reasonably well up till 9/11. Now, some people say, well, almost every application the Justice Department or the intelligence agencies made was granted, but that does not show that the law was not doing something useful, because the very existence of the law and the requirement to have to show to a court albeit a secret court. And by the way, that's not strange. When you get a warrant in a criminal case, it's also done in secret. But the fact that the government had to justify seeking information from a certain person vastly reduced the risk of kind of things that we saw happen and exposed at the Church Committee happening. For example, just to take one extreme example, the government, when it had to seek permission, was not going to try to get permission to bug Martin Luther King's hotel rooms, which they then used to try to get him to commit suicide. That was an explicit effort by the FBI to try and induce Martin Luther King to commit suicide. But if you have to go to a court and justify a surveillance, you're simply not going to try to risk, you're not going to risk exposing the fact that you want to bug Martin Luther King's hotel rooms. So the law worked pretty well up to 9/11, and then the administration began to twist the law. And actually, you could probably...
Yeah, I think that's a great description of the law from 1978 until about 2001. Basically, the Bush administration decided that this regime that was fairly permissive, as Fritz said, granted most applications, even if people had to ask, was too restrictive for them. And they decided that they were going to conduct broad-scale domestic surveillance without any warrant or legal process whatsoever. When that program was exposed by the New York Times in December of 2005, they didn't scrap it altogether. What they did is they brought it to the Foreign Intelligence Surveillance Court and got this court, which had been in the business of issuing individual warrants, to essentially conduct a legal analysis and to give them authority to do programmatic rather than individualized surveillance. They got orders from the court saying that it was legal and constitutional for the government to get orders like the one that Edward Snowden revealed in June of 2013 that said, to Verizon Business Records, you are ordered to turn over the telephone records of all of your customers every day to be stored for 5 years. Now, that's not something that a court that only hears from the government should be deciding in secret. Whether a statute has authorized that kind of surveillance, whether it is consistent with the Constitution, that's something that, and we know that the outcome is different when that kind of program is evaluated by a real open federal court, because when we were able to bring that challenge into an ordinary, not surveillance court, the Court of Appeals unanimously held that the program was illegal and had always been illegal. So what you want is a process, to put it as simply as possible, where the government has to go to someone who's fairly neutral and say, we have a pretty good reason for wanting to know about that person's communication. What you don't want is for the government to be able to do that with no permission, or for the government to get a kind of once-a-year order from a court saying you can do this kind of surveillance on these kinds of people and just report back to us every once in a while, because that leads to abuses.
We have time for a couple of more questions. Up in the back, hand raised, in sort of third row from the back. Standing up, yes, thank you.
Knowing that technology is continuing to make surveillance cheaper and easier to conduct, do you believe that laws and rules will have to become more complex and intricate to combat this trend? If yes, isn't that counterintuitive, since technology is supposed to make things simpler across the board?
I would have a quick answer, and you probably have a better one and a longer one. The first thing is not the law. The first thing is Lincoln's phrase, public sentiment. Get the public worried about the subject, whether that's through art, books, movies, whether that's through another kind of investigation like the Church Committee, whether that's through great journalism. But that's the first and most important thing to do. Get the public on your side and bothered by excessive government surveillance.
So let me give one example of a court, our Supreme Court, kind of confronting this question. So in 2012, the U.S. Supreme Court heard a case called United States versus Jones. Jones was an accused, convicted drug dealer in Washington, D.C. The police or FBI, I can't remember, had gone under his car and attached a physical GPS tracker, and over 28 days had tracked his movements and had used that information to convict him. Now, this question goes to the Supreme Court. Did they need a warrant to do that? Now, the government is amazed that this should even be a question. How could you possibly have a constitutional privacy interest in where you drive your car in public, right? I mean, it would be so simple for anyone just to follow that car around, and you can't say that they, even if they were police, would be violating the Constitution if they followed, right? But the court comes up differently on this, and 5 justices of the Supreme Court, all 9 ruled that it was a Fourth Amendment search, but 5 of them, say that while we know that we can be followed to the liquor store or to the hospital or to the church, we don't go around assuming that our movements can be tracked with granularity over a month-long period. And that can reveal all kinds of information about us, and in fact does. And so that we should have a reasonable, constitutionally protected privacy interest in not being tracked like that over time, unless the government can get a warrant from a judge. Does that make the law more complicated? I don't think so. It just requires it in a situation where perhaps it wasn't required before. However, to take on your point about complexity, look, surveillance technology is complex, and part of the problem that we've had in this country is that there's been an extraordinary asymmetry of expertise between the entities, whether governmental or corporate, that are collecting and aggregating all this information, and the entities, whether they are government or civil society, that are trying to do some kind of oversight over that. And so we're going to need to address that. I mean, the congressional committees that do oversight of the NSA need to have computer scientists on them. And the fact that they haven't is extraordinary. The Foreign Intelligence Surveillance Court needs to have computer scientists and technologists on it, advising the court so that they can do a better job of oversight, so that they can know what it is that they're authorizing. And organizations like mine, the ACLU, have understood belatedly that we need to have technologists on our teams working alongside lawyers if we're going to be able to operate in this world.
We get one last question. Is there over here? Yeah, with the glasses.
You made the point earlier that there is a distinction between government surveillance and corporate probing, whatever you want to call it. I would like to suggest that there isn't, in the sense that essentially everything that the corporations do, everything that the government does is essentially mediated by the corporations, because they create the devices. You mentioned Verizon. They collected the data and were then ordered to give it over. The Internet of Things is going to provide a vast amount of information to corporations who are finding it easier and easier to store that information. So how can we distinguish one from the other? On the one hand, the second part of that is, you talked about the need for the public to become, I don't remember your term from Lincoln, the public sentiment has to be there. But as long as we buy into this notion that apps are free, isn't that wonderful, technology is great, the Internet of Things is wonderful, all of this stuff is wonderful, we can get outraged when the NSA, when revelations come out about the NSA, but fundamentally we're not outraged that we have no privacy left, and that there are no laws that protect our ability to use this technology, which was intended to extend us individually, not to extend the profit margin of corporations.
Well, but as it came out from the questioner who was sitting over there at the last question in the last meeting, there is a difference in degree, in my opinion, between the government capturing data and a company capturing data. The government can do much more to injure you, I believe, than the companies can. And I'll make just one other point. When we did our investigation, one of the arguments we had with the government, the Ford administration, was whether we should reveal the names of the companies that were turning over all their telegrams to the government. And my staffer, who was working on NSA, recommended against it. I said, "You're wrong. We have to reveal the names because they violated the rights of their customers by turning over to the government." And then that went to a vote on the committee, and that was a very close vote. It was not partisan, but I think it was 6-5, and voted in favor of revealing the names. This Congress passed a bill that immunized the companies that were cooperating with NSA, and I thought that was a failure of imagination and a failure of vigor by the Congress more recently.
So just to, very quickly, I think the harms from government surveillance and the harms from corporate surveillance can be understood distinctly. I share Fritz's view that from a civil liberties perspective, I worry more about the entity that can target a drone at me, can put me in prison, than I do about the corporations. But I do not discount the harms that will come from that, particularly if we don't have strong enough rules about when the government can get information from the corporations. If we interpose a warrant in between the corporate collection and the government interception, that provides some protection. I think one of the things that we saw from the Snowden documents was how easy it was for the government to get information from corporations, either through the front door with warrants or through the back door by hacking them and breaking in. So, as to your point about our willing participation in the surveillance economy, I actually think that sets up the next conversation with Ashkan Soltani extremely well, because no one speaks about that with more sophistication and nuance than he does.
Thank you very much.
We have a couple Twitter questions, and I was going to try and put some together and maybe have the three of you all respond briefly to one, which was...
You just killed my transition.
I know. I always want them to write transitions, but they don't. David Brin earlier talked about surveillance and surveillance, and talked about the power of people using technology to fight back, and neither of you really talked much about that. The focus more on the law and how to regulate surveillance. And so I think there was just an interest in people asking, are you at all optimistic about the surveillance approach, the people turning the cameras back, the surveillance back, and is that a meaningful way to fight this? And all three of you can maybe quickly say something.
So I'm very supportive in certain circumstances of surveillance, and the ACLU has endorsed the use of body cameras on police with the right rules. We certainly have defended, long before the Justice Department took our side in 2013, the constitutional right of people to video and record the police. I don't see that as a solution to the problem of surveillance. I see that as helping with other problems, like police violence, right? So to me, it's a sort of critical part of oversight of government. I don't see how it helps us against the kind of problems that we've been talking about. Now, what does help us against those problems are privacy tools like encryption, and there is quite a debate going on in this country right now because companies, including large corporations like Apple and Google, in the wake of the Snowden revelations, have made the decision to design their products in ways that make it much, much more difficult for the government to conduct surveillance, to the point where you have the FBI director giving speeches attacking the most profitable corporations in the world and not just attacking us. That I see as a really valuable Snowden effect, that the most profitable corporations in the world are forced into an adversarial position against the most powerful spy agencies in the world, rather than having them act together hand in glove in secret as they were doing before.
I want to comment on that in relation to what you said before about public sentiment. I do think if we don't just consider it in relation to literal technology worn on the lapel, but the kind of journalism that's facilitated through other modes of social media, blogs, and even different forms of alternative information dissemination. And I was thinking about it in relation to getting this information out of the room here to generate the kind of wider than the audience in this room awareness to raise the public, sentiment that you were talking about before. And I do think that there is a potential in technology with regards to that.
I have a one-sentence comment, which is I think if you look at history, generally speaking, technological change has helped the public.
Love the brevity. Thank all three of our panelists today.